Next item of minutes would be the approval of the agenda.
I move that we approve the agenda as presented.
A second.
It been moved and properly seconded that the agenda be approved. Any discussion? There be none, all in favor, let it be known by the sign of aye.
Aye.
That's unanimous. Next item of minutes will be the approval of the minutes. Madam Secretary?
Mr. Chairman, I prepared and circulated to all the board members the minutes for our September 8th meeting, and I present those now for approval.
I move that they be accepted.
Second.
It's been moved and properly seconded that the minutes be approved that was sent forth by our secretary. Any discussions? There be none, all in favor, let it be known by the sign of aye.
Aye.
That's unanimous. Next item of business will be absentee resolution. Madam Director?
I have prepared for the board a resolution delegating to the director and staff the duties that can be delegated to process absentee ballots. I took the memos from the state board and the director in another county. Her and I went back and forth, and this is the resolution we came up with, trying to make sure that we had included everything.
Have everyone have an opportunity to read the resolution?
Do we
Yes.
have
Yes.
copies of that?
Yes.
I circulated it to everyone.
It's the one you circulated last week?
I have the one, but I circulated the one, yes, it's the same one I circulated last week.
So that would have been before the lawsuits were filed over the weekend to enjoin the enforcement of revised memo 19 from the state board?
I guess I haven't read that one.
So,
So-
according
but-
to my calculation, that's,
So you
the
include
resolution we received from our director came before the petition was filed.
So my understanding is that your recommended resolution includes following revised memo 2020-19 that was revised on September 22nd, but has not yet been signed by a judge. And in fact, there have been 2 subsequent lawsuits filed over the weekend in Eastern District Federal Court to enjoin that memo and the instructions in that memo.
Yes. And
Irene?
So, because I'm not an attorney, and because I guess my mind doesn't work like the two of y'all's, I sat down and made myself a timeline. So there was a closed meeting on September 15th, and the minutes for this meeting were then subsequently made public. That's the meeting where the full board, when it still had 5 members, decided on those sort of parameters. The 2 gentlemen that resigned a week later, which means the decisions that they made are the last decisions, and that memo was based on, are the last decisions we have. The TROs that you're referencing, I believe, have also not been signed by a judge yet. So they haven't been approved or disapproved. There has been no decision. So that memo is the last memo that we have. And I contacted Terry earlier today and asked her if that memo still stands. And she said that the state board had told her that that memo still stands. So those are the rules we have to follow.
Well, here's the concern that I have. You're correct about the September 15th closed meeting setting parameters for how that case would be settled and what a consent order would look like. However, when that consent order was actually drafted, that's when the other board members resigned, and that while that has been submitted to the judge has not signed that order yet. And that changes the law in North Carolina on how we cure witness ballots.
But that's
So-
not up to
May
us
I
to
finish?
decide.
May I finish?
Yeah.
So the only legal authority we have is state law. And until a judge orders us to do something else, remember that the memos we receive are guidance. They are not law, and they don't have the force of law.
But we're not, at least I am not an attorney. And our governing body is the state board.
No, ma'am, it's not.
We can we can go back and forth on this. I'm not an attorney either. But one thing I do know, and I realize, is that we have to follow the guidelines set forth by the state board. And it's true. no court has ruled on any of these petitions.
Mhm.
So therefore, whatever the state board has given us the authority to do, then we have to follow those guidelines.
Mr. Chairman, if I may, I think that the county attorney is here today, and I would be interested in knowing if he's familiarized himself with what's happening and if he has an opinion to express.
Yes, I'll be glad to address the board anytime the board like that.
Yes.
So I can see it from the corner.
Many of us would be grateful.
The existing, and I think it's up through 2025, those are all current valid directives from the state board. The local boards have a statutory responsibility and obligation to follow the state law, but also the state law as interpreted by the Board of Elections, and that's from case law, by the state board. So that's what you have right now. The chair showed me the memorandum that was just filed, I think Saturday, in the motion of the temporary restraining order, and that will probably be ruled on pretty quickly. But your first absentee ballot meeting, I think, is tomorrow, correctly? So right now, you need to proceed with those, following those directives. And let me tell you, and it really should come home, none of y'all were on the board, but we had one of the most onerous cases I've ever had to deal with in the 2016 election. The NAACP filed about 3 counties in the state board violating federal law in a federal election on removing registered voters from the rolls within 90 days of a federal election by the private challenges, the process that we have in place. And the state board had always given guidance to the local boards that they did not regard that as state action because it was taken by private individuals. And there were, I think, 2 attorneys on the board, local board of election at the time, and I know there were some concerns about it, but it was still the directive, and it wasn't just totally off the wall stuff. I mean, if it had been, I think the counties would have tried to, several of the counties, the larger counties would at least have tried to address it some way. But the reason it's important to follow those directives is Cumberland County was one of 3 counties that was sued, as well as the state, and we had to defend that suit, and it was a long, drawn-out thing. During the motion stage in that, the state reversed its position and said, "Oh, we agree with the NAACP that it violates federal law now." So we would have been left out, hanging out to dry. And why the biggest issue for the counties was who would be liable for the attorney's fees. The attorney's fees in that case were for the plaintiffs were over $900,000. So can be a very significant issue. And just last year, I mean, the state agreed. I mean, the AG's office agreed that the state was fully responsible for it. All the counties had followed the state's directives, and that's where they've been. And so the state resolved that whole issue, and the counties were dismissed out of it. So it is crucial that you follow the directives of the state. It is a defense to you, even if you suspect that it's wrong, or particularly if you don't like it. Because if you go out on your own and go against the guidance given to you by the state board, you really are out on your own. So it's I think that as important as this issue is, I think it will probably, there may be an order issued this afternoon or in the morning. It may be before you start your first absentee meeting, but right now, for your preparation, you need to follow these directives. That's my advice.
Mr. Moorfield?
They were my thoughts exactly, and so you just more or less confirming what I just alluded to a few minutes ago.
Mr. Moorfield, may I ask a question?
Yes, ma'am, certainly.
So part of the proposed consent order were 3 memos, 22, 23, and revised 19. 22 and 23 have not been published because the judge hasn't signed the order. Revised 19 was published despite the judge not having signed the order. The hearing isn't until this Friday, in fact, to consider whether he will sign that order. Because one of the defendant parties, the North Carolina legislature, the leader of the House and the Senate in the North Carolina legislature, did not agree to that consent order. And so I think that there's a real concern, and here's the bigger concern, is what the issue is about. The issue seeks to change the process that we had in place in a way that would make it, in a way I think that would put us in greater legal jeopardy. Because if we do, as we do what Wake County adopted their resolution Friday, and they decided to just put it on hold and not follow revised 19 until we get further guidance. And I think that's wise, because once we start sending out letters that say you can cure your ballot by signing this piece of paper and sending it back in and not having a witness, and then we get a court order that says, no, you can't do that, then we're going to have to send those voters another letter and say, whoops, we made a mistake. That's the downside of going with revised 19. The downside of not following it right now and just putting it on hold would be that we would simply be delayed for a few days in corresponding with those voters, and that's what I know Wake County's decided to do.
And there's nothing wrong, I mean, I think you have a meeting set tomorrow, correct?
Correct.
I mean, there's nothing wrong with having, you basically calls me additional absentee meetings that you want to. What I mean, and I think if I understood Ms. Robertson correctly, you have 6,000 already?
For tomorrow's meeting, over 6,800.
Yeah, so, I mean, that's a phenomenally large number for everyone to have to deal with, so
But
you
that's
just
not,
got to keep
but
that
the
in.
issue is whether or not we begin sending letters out informing those voters who have submitted their ballots without witness information, whether we begin notifying them that they can cure that with an affidavit. And if we do that and they send back the affidavit, then the question is, if we do get a TRO, or if we get it, or if we don't know how this is going to turn out in the end.
Right.
There'll be appeals, I'm sure, on either side. At that point, should the decision go the other way, we'll then have to go back to those same voters and tell them, oops, we made a mistake. You actually have to submit a new ballot. So the question is, which puts us in a less difficult position legally as well as practically. Just stopping on that process right now before we send those letters, or going ahead and sending them at the risk of sending them bad information.
But how can we just follow, I mean, we can't just
Let-
follow
let-
the
let-
guidance we like and not the guidance we
Let
don't.
the attorney respond to her.
I think and that's a very good point, Ms. DeVore, but I think it's a practical matter. If you're following the directives that's from the state board to send out the cure affidavit, and then the order comes down after that and says, no, this is not valid, I think it would be addressed, I mean, it should be addressed in the order by the judge as to what counties who had already sent out cure affidavits would need to do. But typically, if the judge reverses that and says, no, this is violation of the elections law, you can't do it, it will just be of no force and effect. So you'll be back to where you were anyway. That's typically how these sorts of situations, particularly in elections cases, because it's also time-driven. I mean, it's not like we can go back, weeks later and fix things.
It's true that we'd be back to where we were with the original memo, but we would, in the meantime, have informed a lot of voters that they could cure their problem in one way, when in fact that wouldn't cure it at all, and we would have to start all over with those voters. So my question is, given that we do expect the TRO will give us some guidance in the near future, would it not be wise to not take that step of sending those letters out today if they're ready to go? Once they start coming in, what are we going to do with the cure affidavit ballots when they come back in? Well, we can table action on them and not actually put them in the tabulator, but if the decision goes the other way at some point, we're still going to have to write to those voters again, send them a new ballot, which was the original cure for that situation, and they'll have to start a process over again. I think there's a lot more confusion to the public, to the individual voters who are our responsibility in this county, if we just, hold tight for now and not give them what may turn out to be bad information.
I know there's at least in the memo, there's a time limit on during which you have to send the cure affidavit. I don't think we're up against that right now. There is, and as Wake County's done, there's nothing wrong with doing that, as long as the board is comfortable that you're going to be able to handle these numbers. I guess, I mean, how long do you want to wait? In other words, if they don't issue, and if the judge doesn't rule on it this week, and then you're up against your next Tuesday's meeting.
We can't do that.
So
Well,
that's the kind of issue.
Well, we don't have any of them back yet because we haven't sent the letters out yet.
Right, yeah, I understand.
I am comfortable with what Wake County did. I thought it was a wise decision to not dig into a hole that you then have to dig yourself out of. If you just stay on level ground and don't start digging, then at least you can move forward from that point and not have to back up and reverse something you've already done. It's my understanding.
Madam Secretary, let the Assistant Member Grimes,
No, I don't, I was listening.
okay, you make it.
It's my understanding that we have maybe a couple hundred of these that need the witness cured on them right now. So in terms of the volume, the 6,000 we can deal with. I mean, that's what we have on our agenda for tomorrow. But these 200, we haven't even sent the letters out yet. But once we do send the letters out, and once they're in the mail, then they're gonna start coming back, and then we're gonna have decisions to make. And the real problem is not the decisions we make, it's that whether we have to reverse those decisions later based on whatever court ruling comes down. It does trouble me that the state board chose to publish, before they had a judge's signature on an agreement, publish the content. That numbered memo was actually attached to as an exhibit to the consent order that has not yet been signed.
I have a question.
That memo and memo 22 and 23 and revised 19 were actually attached as attachments to the consent order, which has not been signed.
Now, it's my understanding that those memos, all that you refer to, have in fact been issued by the state board.
No,
I mean,
no,
if they're not,
22
how, I mean, because I've got them.
Yes,
I've got 'em
they were
too.
they were attachments to the consent order, 22, 23, and revised 19. Revised 19 was subsequently published and sent out to the counties. 22 and 23 were not. And they are not on the State Board of Elections website.
They were sent by Pat Gannon saying we would be getting them, but we have not actually gotten them from the state board.
So there was this,
19, then the revised 19 we have got,
You have gotten the revised 19, is that correct?
right,
From the state board?
from the state board.
Okay. But that's the one, isn't that the
That's
one that
the
has
one
the
that has
cure
the
provision?
cure
Okay.
aspect.
Yeah.
so what I'm trying to
Okay,
do is
I
give you a fuller
understand,
picture.
and it's a board call. I mean, right now, I think with it being, this far out, you do have time. I just think you just need to think about it in terms of how long you wait. There's just no way to estimate how these cases are
I
gonna be
think
decided.
Helen has a question.
My question is actually for Madam Director. So whenever the letters go out to the people whose ballots need to be cured, is there any kind of notice in there informing them that there's pending litigation or TRO as it relates to this particular matter?
Not to my knowledge, it's a form that was developed by the state board for us to send out. I've glanced through it, I have not read it thoroughly, just to make sure that I knew what the voter was supposed to do.
Okay, thank you.
You're talking about the little box that has the affidavit language in it that says you have to include in the letter?
Well, it has all that verbiage in there. She wants to know if there's anything that says there's outstanding litigation.
Well,
There's
I
not.
was wondering
No.
if it was something supplemental. I think you
No.
sent us the, okay, thank you.
So my concern is that on September 15th, there was an agreement in principle to delegate to the state director to negotiate a final consent agreement. And therefore the counties were notified that there would be something like that coming. That actually did come apparently and was ready for court approval on the 22nd, a week later, and it contained as attachments these three memos, 22, 23, and revised 19. For whatever reason, the state published revised 19 but did not publish 22 and 23. None of them, however, have even been heard yet before the Wake County Superior Court judge. That hearing is scheduled for this Friday. In the meantime, there have been 2 federal petitions filed in Eastern District Court, is my understanding, seeking to temporarily restrain that revised Memo 19. And given that we now know that, that is pending, how can we in good conscience send a letter out to someone and tell them, this will cure your ballot deficiency, and have them send that back to us, and then potentially have to send them another letter later saying, oops, we made a mistake. If we simply just wait to see how this is disposed of, in any case, the voters have until November 12th to cure their ballot. November 12th. It's 9 days after Election Day even. We're not on a
No, because
time
that's
crunch.
part of the TRO.
No, it is not. That's
It-
under the
it- I
original.
have it right here.
That's the original numbered memo.
Okay, all right, all right.
I just want to make clarify with the director, it's my understanding that the revised 19 was sent to all the counties by the state board, is that correct?
Yes, sir.
Yes,
Okay.
on the 22nd,
Yeah.
before
That's,
the judge signed off on the agreement.
And see, Mr. Vore, I mean, another way this could have worked is the state board could have sent another memo, okay, everybody put everything on hold until we get
Yeah,
this resolved.
they could have.
And they haven't done that either, so that's the issue. But, I mean, I don't see any problem with putting, just tabling it for, if you, I think this will be decided this week because it
Yeah.
has such an impact. but-
Okay,
So one other
but
question.
it's just
let's
a board
move
decision.
forward.
So
Let's
one
move-
other
Thank you,
question.
thank you.
So
Let's move
one of-
forward. I think we've already had,
Mr. Chairman, I have one other statement I'd like to make. So the minutes of the September 15th closed session of the State Board were released to the public. And in that meeting, the chairman of the State Board made the comment then, it doesn't matter if we get this right, we just have to do it quickly. And I would say that approach is how we ended up getting the revised memo published before it was signed by a judge. And I would say that following that kind of advice actually puts us in jeopardy with our voters, that we potentially will have to apologize to them, that we sent them the wrong advice on how to cure their ballots. And I think it will end up being embarrassing to all of us if that happens. There's a path here of least resistance. There's no downside that I can see. And I would ask you this, Mr. Moorfield, is there any downside to simply waiting until we see what we get from the courts?
If we knew that was going to be like Friday, no, there wouldn't be, but that's the problem. Another way to handle it would be just to put a statement in there that under the current direction from the state board, this is the affidavit, there is a lawsuit pending on this that may change this result. But I mean, so there are other ways to address it. It's really a board decision. But I mean, I think the concerns, your concerns, Mr. Vore, about that can certainly be addressed in the document itself too, by including language like that. So there's a way to go about it.
Okay,
How
Ms.
many
Turner.
ballots are there that need to be cured?
There's probably close to 300 now, if not more.
Okay.
I haven't checked today.
Out of 7,000 that we've had returned,
I can't, what is
so approximately.
Okay.
Would you restate that, please? The balance to be cured are somewhere between 200 and 300?
it? Probably over 300 at this point.
And so have we already prepared and printed the letters that,
We had letters prepared and printed through Friday.
and they've not been mailed?
No, they do the mail run this afternoon.
And they do not say anything about any pending legislation?
No.
So at the very least, if we took the county attorney's advice, we would have to redo those letters.
We could always put an extra piece of paper in there.
They're not sealed up yet.
No, they get sealed at the mail.
Thank you.
Okay, we have before us this resolution, and thank you for your comments, and thank you, Mr. Attorney, for your information as well. Again, we have before us this resolution. We've all had an opportunity to read a copy of it. What's your pleasure?
Mr. Chair, are you referring to the director's original resolution or the revised
The
resolution?
director.
I would move that we accept the resolution as prepared by the director and circulated to us as the members of the board.
I didn't quite understand you.
I would move that we accept the resolution as prepared, the original resolution as prepared by the director.
Oh, okay. It's been moved that to be, accept the resolution as prepared by, Executive Director. Do I hear a second?
A
Is that
second.
okay. Been moved and probably seconded that the resolution sent forth by, Director be approved. All in favor, let me know
No,
by
there's
saying.
discussion, sir.
There's discussion, Mr. Chair.
Discussion, I'm sorry, yes, discussion.
May I address, please?
Yes, you may.
Thank you. Mr. Chairman, could we have a 10-minute recess?
For what purpose?
I need to think about this a little bit before I vote. And I think it would be wise if we all just took a little breather and took a 10-minute rest, and let's think about this very carefully before we do it.
I grant 10-minute recess. Chair, call the meeting back to order. On the floor, there's been a motion made to accept the resolution presented by Executive Director. It's been
Mr. Chair,
properly seconded.
Mr. Chairman,
Yes, Madam Secretary.
I would like to offer an amendment to the motion.
And what is your amendment?
My amendment would be that there has been an additional version of the resolution circulated that it differs from the original resolution in several ways. One is that it allows board members to participate in the duplication of ballot process, just as we have done in the last 5 elections that this board has been together. And secondly, it instructs that we would, or we agree to follow the original numbered memo 19, and rather than adopt the process that is not provided for currently under any legal precedent, given the fact that we know it is currently before 3 courts, and we do not know how that's going to be resolved. So it offered those 2
Point of order.
amendments.
That's not an amendment.
Yeah, it is an amendment.
No, you presenting an entire,
You want me to offer the amendments one at a time?
You could do that.
Okay. So first of all, I would offer an amendment to paragraph 3, ballot duplication. The original memo that the director recommended to us suggested that the board members would not be involved in the duplication process, as we have been in the past. My amendment would, on paragraph A, would read, a bipartisan team of board members will duplicate ballots before the conclusion of the absentee meeting or immediately thereafter in order that the duplicate ballots may be counted at the next meeting. This is a reference to the Uakova ballots, the ones that come to us by email. These are the people who are overseas or overseas military.
Okay, you're making a statement, you're not making an amendment.
I was just wanted to
What is
clarify.
your amendment?
I just stated it. That we amend paragraph 3A to allow a bipartisan team of board members, who could certainly be assisted by staff, but to do it the way we've been doing it over the last.
You're making a statement again, Madam Secretary. So what is your amendment again? You want a bipartisan team of board members
Yes,
to be involved with duplication of ballots.
yes, sir.
That's one item. Okay?
That's an amendment, yes.
Okay.
Does that have to be seconded?
If the maker of
it
the,
does.
if the maker of the original motion will accept it as a friendly amendment?
I'll
Yeah.
accept that one as a friendly amendment.
Has to be seconded.
Second.
Okay, we vote on the amendment only to be added to the original motion. It's been moved and properly seconded that a bipartisan team of board members would duplicate the ballots before the conclusion of the absentee meeting.
Mr. Chair, I believe the current guidance from the state is that there has to be 3 people involved in ballot duplication. There's only 5 members on this board, which means only 1 set can be duplicated at a time, which means it's gonna take forever.
Actually, this is only the Uakova ballots. These are the absentee and military overseas, overseas and military overseas ballots. While we've seen a huge increase in the number of people voting absentee, we do not have a increase in the number of our voters living overseas and voting. Nobody's moving overseas to cast a Uakova ballot. So I would suggest that it's not anymore of a volume of Uokopa ballots than we've seen in previous presidential elections. And by retaining board authorization to do that, we allow ourselves to include members of the staff in the process, but it would be our responsibility.
Madam Secretary, let me interrupt you again. There's motion on the floor to approve the amendment as you suggested, and I've already read that amendment off. Do I hear a second? Did someone make a motion?
Bobby seconded it.
You second? Okay.
Yes.
Been moving probably second that the amendment, a bipartisan team of board members will duplicate ballots before the conclusion of these ballots. All in favor of that amendment, let it be known by the raise of hands.
Would that not get a discussion first or no?
We've had that discussion.
As to,
Just the amendment.
Just the amendment, we're just voting on adding the amendment.
Just the amendment.
all right.
Yeah, does everybody understand the amended motion? Or the motion to amend?
It's just a motion to amend.
Yeah.
Motion to amend. Everybody,
As to that paragraph.
all in favor to motion to amend, let it be known by the raise of hands. It carries the majority vote, amendment to the motion,
Mr.
which
Chairman,
would be included on the motion, the previous motion.
and Mr. Chairman, I would like to offer another friendly amendment.
Okay, go ahead.
I would like to offer an amendment to paragraph 1, B. This is where, and this is the discussion that we've had already, but I'd like to raise it as an amendment to this motion.
This is paragraph 1B to the original
To the
resolution.
original resolution, the one that's on the floor. The original resolution reads that staff shall follow the cure process outlined in numbered memo 2020-19 revised on September 22nd, 2020. I would offer as a friendly amendment that we substitute for that language, this delegation does not include curing a witness or assistant deficiency by voter certification, but does include administrative duties related to spoiling such a ballot and reissuing a ballot. And let me say that in offering this amendment, I understand that doesn't require us to spoil ballots and reissue them at this time. It simply reinstates the original cure process under the original numbered memo 2020-19. I offer that as a
Point of
friendly
order,
amendment.
Madam Secretary, in that you mentioned memo, the revised edition of memo 2020-19 on September 22, 2020. I have not seen that memo, the revised memo. Has anyone on
Yes.
board member seen that revised?
Yeah,
memo?
yeah, it was
Yes.
distributed to us. I have a copy. Do you want to?
It was attached.
to all board members.
Yeah, in
It was?
addition to that, it was attached as an exhibit to the proposed consent agreement, which the judge has not signed. It was part of a negotiated consent agreement,
Oh,
which
yeah,
has not
okay,
been agreed to.
okay, yeah, okay, I'm sorry. Wait. So what is your amendment to the?
I offer I offer new language for paragraph 1B, that rather than following the cure process outlined in numbered memo 2020-19 revised on September 22nd, in anticipation of there being a consent agreement, I offer instead this language. This delegation does not include curing a witness or assistant deficiency by voter certification, but does include administrative duties related to spoiling such a ballot and reissuing a new ballot, which is the original numbered memo 19.
Okay, I would like, Mr. Chair, could we get somebody who's not an attorney to explain that to me?
I can explain it as a non-attorney. So what it is, what it's saying is, for if the person forgot to sign and say, yes, I witnessed this, the memo is saying we'll send it back out and let them cure it. But what, Secretary DeVore wants it to be done is be spoiled altogether and resent.
Well, it's not what I want done. That's
Or that's what you're saying we should follow according to what Wake
Well,
County is following.
putting aside the substance of whatever the memos say. I think as a matter of process, that following a memo, which is part of a negotiated settlement, which has not yet been agreed to by the parties or signed by the judge, is a process error. And that the jeopardy we put ourselves in is that once we step out on that ledge and start sending those cure affidavits out and voters start returning them to us, and we're still waiting for.
I understand, you're giving an explanation of what you think, but that's what this says, is that instead of us saying, here, here it is, that this revision that they're requesting or doing in Wake County actually in fact does say, spoil that one, send out a new one. So that simple is what it is.
Okay, so.
But your explanation as to why you want it is something different.
Okay,
Yeah,
so,
Madam Grimes?
I think, this paragraph, as suggested by the secretary, substantially alters the resolution that the director presented, and B, does not follow current guidance from the state board, so I wouldn't agree to that.
so let me.
Okay, no.
Let me
Further discussion.
restate.
You've already said, be prepared to vote on this amendment.
So I will withdraw that as a friendly amendment. Instead, I will
Okay.
substitute this friendly amendment.
Okay,
This is what I would offer instead. This delegation does not include curing a witness or assistant deficiency by voter certification, end of sentence. It would not direct our staff to spoil ballots. It would simply put the process on hold until we hear from the courts.
what paragraph are you reading from?
From 1B, I offer as a friendly amendment that replace the recommended language with this language. This delegation does not include curing a witness or assistant deficiency by voter certification, period. It does not, by offering it in that way, it does not direct our staff to spoil any ballots. In other words, it just puts the process on hold.
Let me clarify on that. Right now, memo 19, 2019 is the revised version. And it's in all, well, not all of it, this way it says it's part of the supervisory authority of the state boards and power to compel observance by county boards of elections laws and procedures cited in 163, 22C, statute on that. But, Mr. Boyer, if your motion, you don't have to delegate anything to staff. I mean, the resolution gives the board the opportunity to delegate really all of that or whatever it wants. But the way this works is if you don't delegate it to staff, it stays in the board's lap. So just make sure that the board understands that.
And that, if you don't mind, that's part of my sort of problem, if you can call it that. The staff is in the administrative sort of side of this, and probably many other sides, a lot more knowledgeable than we are. So I think we're doing better letting them do their jobs.
Well, I don't
And
think
to be
that's
clear,
the
this
issue.
is the 444 that we're referring to?
Yes, so far.
So far.
I said to be clear, so that everybody know that these are the 444 ballots that we're referring
Yes.
to, and that's only the beginning.
Yes.
So then that means we would then have to make ourselves available to go through however number as opposed to leaving some things within the director's discretion.
No, I don't think that's the case at all. The 444, the question is, how will we go about curing them? And the courts haven't told us yet how
I
to do that.
understand, but what the county attorney said is if we realize that, then it leaves it in our hands, in our laps, and therefore we would have to be the ones to make the decision over it in a situation where we're taking that authority, if I'm correct, away from the director. Is that correct?
Well, actually, the resolution proposes that you give the authority to
Yes.
the director.
And-
You already have that responsibility. This is a delegation of the things that the statutes allow you to delegate, and in accordance with what at least this one, the new 2019, which the revised version is the only version of that now, so.
I guess what I'm doing is I'm saying it in reverse. The director is saying, as she has in the past, you guys can give me the discretion to do this, And if you don't give me the discretion to do then we have to come back every time and we have to make those decisions. Now, in the past, we have said that we rely upon the director and she's been fair and we've not had any issues in this county, but now we're coming in saying, well, we want to take this particular part back
No, I think you're looking at paragraph C.
or keep this part.
You're looking at paragraph C, and I'm addressing paragraph B. So paragraph B is about a curing process. It doesn't have anything to do with us approving ballots. Paragraph C is when the director will separate it into stacks and bring them to us for approval. Those are two different processes. Right now, we're talking about a pre-approval process that takes place before we ever, in any circumstance, would see the ballots. It's about what do we do when they first come into our possession at the Board of Elections? What does the staff going to do? And the question is, are we going to tell them to send the new cure affidavits out that are in question and being challenged in the courts, or should we tell them to just sit still on that and wait for and essentially wait for further direction from us, which we can provide further direction at any time?
Madam Director, are you asking that whenever you have these issues that need to be cured, that you are allowed to just send that back with notice that it needs to be cured without coming to us? Because otherwise you would have to come to us each time you have a batch that needs to be cured. Is that what
Yes,
you?
ma'am, because this memo says it must be done within 24 hours of receiving one that needs cure.
So then that would mean that if we do not give you the authority and the directives to do so, then when you receive them within 24 hours of receiving them, then we would have to reconvene as a board and making a decision on those particular ballots. Is that correct?
That's correct.
Okay, so what I propose under paragraph B is that this delegation not include the new cure affidavits. It's not about not delegating what's in C. Under C it says, staff shall perform an initial review and sort of ballot envelopes into categories and present those recommendations to the board at each absentee ballot. And I propose adding a sixth category, which is those that require witness curing. Those stacks would all be presented to us the same way they always have been. The staff would still be pre-sorting them all to us. What I'm talking about in paragraph B doesn't relate to that at all. Am I right, Madam Director?
I kind of lost you because I can't hear you real well.
Okay.
But
I'm
let
not-
me
I'm
just
not
point,
propos-
I just want to point out the fact that this morning when I was on what we have, a Monday morning huddle where the directors are on with the state director, this issue came up. And it was said in that meeting doing the cure process. And the answer was, correct. County board members are required to follow state board numbered memos, and the cure numbered memo has been issued and must be followed. And that's what I'm asking that you allow me to do.
The only comment I would make about that is
Let's
that
vote.
that's the whole subject of the lawsuit, is whether or not that cure affidavit process in that memo that we're referring to, that the state board director has issued, whether or not it follows North Carolina law, or whether it creates new law, and whether or not a judge is ever going to approve it.
Believe me, I don't want to do double work, so I don't want to send something out and then have to redo it. But as being directed by the state to do it, that's what I'm supposed to do.
Okay.
So I'm asking permission to do what I'm supposed to do, even if it means I have to do something else down the road.
Madam Grimes,
Let's vote.
Madam Director, would
you call for a vote?
Madam Director,
I do.
Madam
Okay,
Director,
I'm sorry, but it's been a call for a vote.
are you shutting off discussion?
But
That
I mean,
takes
call
a
for a
vote.
vote automatically.
That takes a vote.
Call for a vote automatically ends the discussion.
No, it does
Okay.
not. You have to vote
Yeah,
on that,
now,
Mr. Chairman. You have to have a motion to close
Well,
discussion.
I would move to close discussion.
It's been moved, this discussion be closed. Do I hear a second?
Second.
The moving probably second, discussion be closed. All in favor, by sign of raising hands.
What are we voting on?
So
Close
to
the
Close the discussion.
Oh, okay. Sorry.
Okay, now, your call for the vote made that.
Yeah.
Okay? That
we
means,
still have to act
now,
on.
you still have to make a motion for your amendment,
I did make an motion for my amendment.
the third amendment.
No, the second amendment.
I thought you tabled that,
No.
no?
I
let
think
me
that there were
clarify.
several amendments to the motion that,
Let me clarify.
was being made.
So we just closed discussion on the amendment that I proposed for paragraph 1B. 1B,
Okay, fine.
okay? I made a motion to amend, and now we should vote on that motion.
Okay,
to
motion
amend.
been
Well,
made,
to be-
who seconded it?
I would say that I would object to that. I would not accept that as a friendly, amendment to my motion, my original motion.
Okay. Mr. Chairman, I would like to propose an amendment to paragraph 1C. And I think this one we should really consider seriously. It has nothing to do with the numbered memo. In paragraph C, we direct that the staff shall perform an initial review and sort of ballot envelopes into categories and present those recommendations to the board at each absentee board meeting. And the categories shall include, and the director, because this was written before all the legal challenges came up, divided our stacks into five categories. I suggest that we add a sixth category, and that sixth category would be ballots recommended for approval with an absentee cure certification for witness deficiency. And the reason I offer that as an amendment is because I think it is important that we have those in a separate stack for approval, so that if we have a court order which does not allow that process to be implemented, we will know which ballots we have to relook, that we have to reconsider, and then we have to send out a new letter on, and they will not have, at that point, been inserted into the tabulating machine and have to go through an elaborate retrieval process.
Again, Madam Secretary, you're making a statement and the speculation, depending upon the court order. That court order has not been issued, has not been decided upon, so therefore we can't move on this amendment.
No, sir, I'm offering the amendment that we add a sixth category of ballots recommended for approval with an absentee sure certification for witness deficiency. I'm simply asking that the sort of the ballots by the staff be into 6 stacks rather than 5, so that we have a group that we can identify, so that if there is a court order that comes down this week, we'll be able to, we'll have those ballots separated out.
Okay, board members, you heard the amendment. It's too long for me to repeat. You've heard it. All in favor of the amendment, let it be known by a sign of raised
I
hands.
have a question.
Wait,
Yeah,
hold-
we
hold.
don't have a second.
Let me get the motion on the floor, then you
Okay,
have a question,
okay.
okay?
I think no one seconded
Let it-
that motion.
Uh,
No one
It has
seconded.
been second? I don't think it's been second before your vote.
No, I was going for a
Oh,
second.
okay.
Is there a second?
Second.
Is there a second?
Second.
Okay.
Did you ask for a second?
Yes, I've been moving probably second that the motion you heard from, coming from my secretary. Any discussion?
I do. So are you saying for 6 that ballots require further deliberation by the board? Is that what your motion is?
So the sixth category would be ballots recommended for approval with an attached absentee cure certification for witness deficiency. So there would be so we have already 5 stacks we're considering. This would be a stack that separates out those with the attached witness cure affidavits on them, so they don't get inserted in the tabulator machine before we have a court order, because it's a long process to have to retrieve them. No harm.
If I could just ask, Madam Director, what is your position on that?
I have no position on that. I mean, the law states the ballots that have been returned and approved must be inserted at the tabulator if that's our process at that meeting. If you do not approve them, then they don't have to be inserted.
Is there, so when the absentee ballots come in and are presented to the board, right? Our options are to either approve them or disapprove them. There's no option to like hold them for later.
If you
Table.
disapprove them, then we're gonna go back to the computer and put them in as disapproved ballots.
So is that classified as rejected ballots?
So, Mr. Moorfield, perhaps you could clarify for us, though, that on any particular ballot, and I know we've done this in the past, we can table a decision on that ballot or group of ballots at that meeting.
Yes, to a time certain, as long as you stay within.
And so that would allow us to consider doing that, particularly if we have continuing breaking news on what's going on in the courts. And I'm saying without that separate stack, we don't even know which ballots those are.
May I ask a question, Mr. Chair? Ms. DeVore, are you really just asking that staff keep a separate identification process for the ones that they have disapproved?
No, it has nothing to do with this.
I mean, that they were found a deficiency in to send the cure notice. Is that what you're?
No,
what you're doing? Okay.
I'm asking that there be, they send us, all the ballots that have been sent back so far and are ready for board consideration are separated currently under the director's proposal into 5 stacks. I'm asking that we have a 6th stack that simply identifies which one have this particular new memo 2019 revised attached to them. So that if we are required by a court to go back and redo it, we'll know which ones to redo without having to sort through them all.
So, but wouldn't that essentially be saying that we're still not going to follow the directive
No.
from 19, essentially, if we're going to hold them and wait and see what the court
Well,
decides?
we would hold them after the cure. No, we wouldn't be. We would be following the directive. We'd be sending the cure out.
So you're saying, go ahead and send the cure out, but hold them and not do anything with it until we hear back from,
Or at least know which ones we might not want to do anything with right away. I mean, we could table decision on accepting back the ones that have been cured by this method that's in question right now and before the courts.
Can you go back to see, and it says the categories will include designations for recommended approval. And it says those recommended for approval with an absentee cure certificate. That would mean that certificate's attached to it. Is that
Correct.
what you're asking?
No, I'm asking that you add a separate category, and if you have my suggested revised resolution, I added a 6th category for those that were specifically recommended for approval with this specific absentee cure certification for witness deficiency. So that's specific.
So
We
you
have
want
other
it-
kinds of cure affidavits.
Okay, so you want them broke down as to,
What kind of cure affidavits attached?
was it the
Signature,
signature
or was
of
it the witness?
voter or the witness?
Correct.
Or do you want the signature of the voter or the witness that didn't put his
Correct.
address? I mean,
Correct.
there's 4 or 5 more columns there.
Well, I'm only asking, though, that there's no dispute that we're gonna utilize cure affidavits for the voter's signature. There's no dispute there. So that would be one category. There is a dispute, however, before the courts on whether or not the cure affidavit for witness signature is going to be adopted ultimately. So I'm only suggesting that those 2 stacks be separate instead of all one stack. I think it would be really helpful,
I mean, I have them sorted that way now.
okay?
So this is not a big deal to you?
No.
Okay.
Good.
and so just to be clear, there would be no delay and nothing would be sitting waiting for something to be sent out. We'll already have
No.
everything back, and it's just a matter of inserting it into the machine,
Well,
if it's approved.
we've already turned down.
If I could just start with a yes or a no, so I can have clarity in my brain, what you're saying.
Maybe you can restate your question then. I didn't.
Restate the question, Ms.
Okay,
Nelson,
so my
please.
question is, you're saying that it's sent out to be cured, it comes back, but we just hold it until we have a decision. And then once the decision is made, then we'll know to insert for counting,
Correct.
or we
Correct.
spoil them or whatever.
That's right. There's less downside, I think, that way.
Well,
Madam Director? So I am assuming that there would be a secure way of keeping these particular ballots Because they've already been opened, or we're just looking at the back of it, the signature of the back of it. And so they would continue to be securely kept in a location like they have been.
Until they're approved by the board, just like we do in a regular board meeting.
And that decision is going to be made by, prior to November the 3rd. So what happens if it's not made by November the 3rd? Those ballots that we set aside, waiting for the court to make that decision, what do we do with those, them?
I think there will be.
Well, you know, I mean,
We can
that's,
circle back on this anytime we choose to. We can
so if the court has not made a decision, in that regards, then those ballots that were set aside will be brought out and vote, and either rejected or
Well,
approved.
that's our board decision what to do with them at that point, but I guarantee you the courts are gonna have to come to a decision before we get to November 3rd.
Well, that all depends how the court's made up.
But yes, the answer to your question is they'll be set aside, that they don't go anyplace, they're not going away. We can circle back to them at any meeting we choose.
Yeah, by November 3rd, something will have to be done with those ballots, either approved or
Yeah,
rejected.
Of course.
Yeah.
And my only thing in regards to that, though, is, because I do believe the chair has raised a valid point, so if we wait until the absolute last moment that we can wait, then we could, potentially have a large amount that would have to be dealt with in a short period of time. Is that correct?
That's correct. We
But they've
already
al-
have 444.
But they've already been reviewed by staff. They're not sitting unattended to. They've
Yeah,
already
I
been.
understand that, but even with, if it's just running them through the machine, that can be time consuming whenever you're talking about, the ballots. Isn't that correct?
It would be a meeting, just like an absentee meeting, yes.
I mean, we have 7,000 to consider tomorrow. We're talking about hundreds in this case, not thousands.
I understand that, but
Okay,
we're talking about
we can have
hundreds
the
added to the thousands that we're already gonna be reviewing.
Well,
I'm sorry to interrupt, but we're running out of time for this facility. So we're gonna have to go ahead and vote on this amendment.
I'm
so we
sorry.
So we can get to the
Mr.
main
Chair-
motion?
Mr. Chairman, this is the main motion. We're just talking about amending it.
No, we're talking about the amendment,
Right. So,
which is the,
so Helen, I think what I'm trying to say is that there's no reason to believe
madam, would
we-
you mind repeating your motion, motion again to the amendment?
My motion is that we amend paragraph 1C to add a sixth category of ballots, and those that are coming as recommended from the staff, already reviewed. And that amendment would say, ballots recommended for approval with an absentee cure certification for witness deficiency. I'm just asking that instead of having 5 stacks of ballots to consider, we have 6 stacks of ballots to consider, and that we know how many we have in that 6 stack, and that we will be able to consider them as an issue separate from the other categories.
Okay, you heard the motion, there was a second.
Yes.
Second?
Yes, sir.
Okay, it's been moving, probably seconded, that the motion you just heard be approved. Before we had discussion, all in favor of the motion, let me know by the sign of raised hands. All those opposed, with sign of raised hands.
So it looked like fools.
Okay, that motion did not carry. Now we go back to the main motion, which is the director's recommendation to the resolution. The motion's been made, it's always been probably second, that we accept the debt resolution along with the members that have already been approved. I don't think there's any need for any further discussion, but if you want to discuss it, we can.
I would
That's
just-
good, all in favor of the?
I would just clarify that there was only one amendment that was approved.
Yes, one amendment, yes. All in favor, let it know by the sign of aye.
Aye.
Or raise hands, I'm sorry, raise hands. That's the majority. All opposed by the sign of raised hands? That's the minority, majority rules. Okay, so Chair would declare that the resolution presented by the executive director is approved. Madam Director, you have any further reports?
I have none. No.
No? Oh, I'm sorry, okay. Is there any further business to come before the board?
No, sir.
No further business? Then I declare this meeting adjourned.
Thank you.